Well, sad segment here. A family who lost their only son to a drunk driver recently settled a lawsuit against a convenience store who sold the alcohol before the crash. Attorney Jim Higgins with the Higgins Firm recently stopped by our studio to tell us what happened in this terrible case and when someone can be liable for serving alcohol. Take a look. All right, we've got Jim back with us today. Good to see you again.
Thank you.
All right, we're talking about a really tragic case that happened pretty recently. Tell us what happened here.
Yeah, this was a family in East Tennessee whose son was killed by a drunk driver several years ago. And after that happened, the family, to try to get some answers, filed a lawsuit. But they filed a lawsuit not just against the drunk driver. They filed a lawsuit against a store or a market that sold that drunk driver his alcohol, his beer. And those cases are really tough in Tennessee, but fortunately I think they were able to gather enough evidence to prove what they have to prove under the law in Tennessee, and they were able to resolve that case with them. And the family said, and it's the same when I represent families in cases just like this, they could care less about that money. This is something that they wanted to do to make sure it doesn't happen to another family. If they could ever trade any of that out to get their son back, they of course would in a heartbeat.
Absolutely.
But it's also important to make sure that all of our laws that we have are enforced, and so this doesn't happen to somebody else's kid. Right.
So let's talk about the laws here in Tennessee. When can somebody be liable for serving someone alcohol here in Tennessee?
Yeah, it's tough. Our legislature has made it really tough to hold an establishment. It's kind of a business-friendly statute. But what it says is that the only way that you can hold a business responsible for selling alcohol is if, one, they sold it to a minor and they knew that person was a minor, or two, that they sold it to someone who was obviously intoxicated, and a jury has to find what we say beyond a reasonable doubt, which is a real high standard, like a criminal standard,
right,
that was the proximate cause of the accident. So those are all really hard things to do. And one thing that's important to note, when they made that statute, they put in intentionally the word sell. So it's almost impossible to hold someone responsible for having a party and just giving alcohol away. Now, you can still be held criminally liable if you're serving minors or things like that, but there's really no liability for that in Tennessee.
Right, definitely. All right, well, before we go, let's talk a little bit about, is there anything important that we should know during cases like these?
Yeah, so what I think is important, I guess, from a lawyer standpoint, is when we get these calls in our cases, of course, we're always looking for who may be responsible when someone dies or someone's seriously injured. I mean, we handle a lot of heavy cases, and so time is crucial. And nowadays what we're wanting is to preserve any evidence. If I get that call on a case like this, we're going to file as soon as we can. We're going to subpoena videos from that store. We're going to look at records as to when they were paid. You're going to look for witnesses that may have saw this person before or after going into that market to say, yeah, this guy was obviously drunk. He had no business getting sold alcohol.
Right.
So time is important, and getting that evidence is crucial.
All right, great info. Jim, thanks so much.
Thank you.
And the Higgins Firm is serving Tennessee. Give them a call at 1-800-705-2121 or go to thehigginsfirm.com.